Your Honor, you're on mute.
I know, sorry. Good afternoon, everybody.
Good afternoon, Judge.
Good afternoon. Good afternoon. Good afternoon.
Judge, you're muted again.
I'm gonna blame it on all the rain we got this morning. All right, now we're ready to start. Good afternoon, ladies and gentlemen. My name is Judge Regina Mincy, and we're going to begin with our Fulton County State Court Expedited Accusations calendar. This is the calendar for cases in which individuals have been recently arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused the cases of the offenses brought against them, and the cases have been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge. So we're going to address several matters, including bond, possible arraignment, and a possible plea offer if one has been made by the state at this juncture. I'm also going to be providing you with a reset date if arraignment is not held today. And what is that reset date, Mr. Jordan?
It's for 2022, April 28th.
Okay, April 28th, 2022 would be our SAP reset date, April 28th. I'm going to begin also by advising everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube, so govern yourselves accordingly. I want to also inform the defendants on this case and remind you of your constitutional rights, that anything that you say about the facts and occurrences of your case and any statements that you make about your case can and will be held against you. Prosecutors are obviously on this Zoom forum, and they will be listening. So listen to your attorneys and act as they ask you to by not speaking. All right, we're going to start which one? Courtroom 2?
Yes, good afternoon, Your Honor. This is going to be position number 1, Mr.
Okay.
Anthony, position number 1.
All right. This is case number 22 CR 002273J. Is it Jabray Anthony? Jabray Anthony. You're charged with 1 count of possession of marijuana less than an ounce with the offense date of April 15, 2022. Pre-trial, do we have anything?
He has a total of 7 cycles, 1 out of Florida, 3 out of Alabama, and 3 out of Georgia. He had a 2021 conviction for fraud out of Florida, which he's currently on probation for that case. It was 3 years probation. He had a 2017 conviction out of Georgia for fleeing or attempting to elude. And his last arrest was October 23rd of 2021 for identity theft out of Fayetteville. And that case appears to be open. There's no disposition listed. Nothing further.
All right, thank you. Yes.
Yes, Your Honor. He also has a hold. There's an extradition hold on him out of Alabama. I don't know what the charge is because it doesn't stay. However, given the fact that he does have an extradition hearing, the state is willing to offer him time served on this case if he would like to accept that responsibility today.
Yeah,
All right, Ms. Thomas.
Yeah, and that's the first time it's been communicated to me. I haven't had the chance to speak with Mr. Anthony about a time served offer, apparently. Well, obviously, Your Honor. So if Mr. Anthony would like a breakout session to consider the option, we can do that, or we can just proceed forward with bond.
All right.
can I get the breakout session?
I didn't hear you.
He would like a breakout session.
Breakout session. All right. Are you on the next few cases, Ms. Thomas?
Yes. Yes, Your Honor, I am. But majority of my cases are in the South Annex.
Oh, okay.
So
Mr. Jordan, you want to go ahead and put them in a breakout?
Your Honor, Ms.
Yes,
Thomas,
sir.
can you call that number 22392?
Okay.
And here go to the phone.
Okay, that'll be a little easier. Thank you.
Yeah. Is Ms. Kim having issues logging on? Because I don't,
She's,
She's on.
she's
I
on.
am here. Yes, I am here.
okay. So
Oh,
we're
okay.
gonna go through all Ms. Kim's cases.
Okay.
George, what's that number? You said 2391?
It's 22392, the 92 number, not the 91. 22392, that's 612-2392. Holmes.
All right.
So we're gonna go to position number 7, Mr. Kendrick Holmes.
Okay. This is case number 22 CR 002279 G. Kendrick Holmes. You're charged with 1 count of simple assault, family violence with the offense date of April the 15th, 2022, pretrial.
Yeah.
That's 3 cycles. Last arrest was April of 2021 for a criminal trespass in Glenn County. Has a 2017 conviction for no license on person. And then he had a first offender for criminal trespass and battery family violence from 2019. It was sealed in 2021. And nothing further. He's recommended for pretrial.
Thank you. Ms. Melnick?
Yes, Your Honor. The victim in this case is Kenesha Cooper. And the facts just show that she did grab her and punch her in the face. Given the fact that she does have another family conviction for battery family violence, and it would be a felony if that one was not a first offender, we are asking for a $7,000 good bond on this case. It was recent in time, 2019.
All right, Ms. Kim?
Yes, Mr. Holmes is 29 years old. He has no objection about stay away or no further contact. And yet we are opposing for $7,000 surety bond because he has to start his new job this coming Monday. He's very anxious to start his job, to work at warehouse so he can provide food and bread to his 3 children, 11 years, 8 and 5 years old. So he graduated from high school here in Georgia. He has lived here in Georgia for 29 years. And he also went to South College for about 1.5 years to study for business. So we would like to request for signature bond. And yet, if Your Honor is not inclined to give him a signature bond, we would like to request for $500 surety bond as low as we can because he has to start his job on Monday. Thank you, Your Honor.
Your Honor, I'm so sorry, I forgot to add, it's still early in the Saturday, that we'd also would ask to stay away from the incident location 333 Peachtree Road, to stay away and have no contact with Kenesha Cooper and to have no weapons, drugs, or alcohol while on bond. I apologize for that.
That's okay.
I don't-
We would have gotten there.
I don't know who Commissioner Cooper is. Like, that's not me. My thing was with Brooke Road.
Hold on a second, Mr. Holmes.
I mean, it's all on the paper.
You are Kendrick Devonta Holmes, is that correct?
Yes,
Your Honor, if I may interrupt, the victim is Brooke Roach. This is my case. If I can proceed with the bond hearing.
Uh-oh.
I'm sorry, I have them listed in a different order. Sorry.
Yeah, I told you we're gonna blame it all on this rain that we had.
I
Okay,
blame the fact that that's since 6 this morning.
sorry, everyone. And I apologize to you, Mr. Holmes. Let us start over, okay? All right, but we still do have the right case number, 22 CR 002279G. Ms. Tartarella?
Yes, Your Honor. What I'm recommending for this defendant is a $5,000 surety bond. The conditions is that he have no contact with the victim, Brooke Roach. The first and last name is traditional spelling, to stay away from 855 Roswell Creek, Apartment C in Roswell, Georgia. A 1-day anger management, no weapons, no drugs or alcohol, and no new violations of Georgia law. Your Honor, in this case, the defendant, Kendrick Holmes, he swung his arm at the victim, Miss Brooke Roach, over AirPods and money that was owed to him. This occurred on April 15th, 2022 at approximately 4:41 p.m. An Officer M. Cassano of the Roswell Police Department was dispatched to the incident location at 855 Roswell Creek, Apartment C in Roswell. Upon arrival, the officer did speak to the victim, Miss Roach, who advised that she was involved in an argument with a defendant, her boyfriend, Kendrick Holmes. Miss Roach advised that she and the defendant had been living together at the location for over a month. Miss Roach advised that she had come home with her 2 children when the defendant started to argue about money that was owed to him. She was still in the vehicle at the parking lot with her children inside. The defendant then began to bang on the windows and then tugged on the door handles of Miss Roach's vehicle, all while demanding money that she owed to him. Miss Roach stated she contacted the police, and while she was waiting for law enforcement to respond, she observed the defendant come in and out of the apartment several times. Then Miss Roach said the defendant walked past her vehicle, quickly stopped, and after stopping, he swung his arm toward her through her open car window in an attempt to hit her. Miss Roach provided ring video footage to the officer where the officer was able to observe the defendant swing at Miss Roach. The officer did speak to the defendant, who advised he tugged on the handles of the vehicle in attempts to speak to Miss Roach. The defendant also advised he tried to reach in the car to get his AirPods from Miss Roach because he needed something to sell since she wouldn't give him the money. The defendant was arrested, and all these events did occur in Fulton County, Georgia. Your Honor, I do understand that the defendant has a light criminal history. He has 3 cycles right now. However, my bond recommendation is due to the fact that there are prior difficulties. We did speak to the victim. She did say that 3 weeks ago, he did strangle her to the point where she could not breathe, but this was not reported to police. The state does have concerns of the fact that the defendant will intimidate this victim. He knows her, they've been in a relationship. He knows where she lives. According to the victim, they are no longer in a relationship, and there is no need for him to come get his things, as I believe she stated, let me look at my notes, Your Honor, that his belongings already packed in his car. For that reason, Your Honor, the state does recommend a $5,000 surety bond, nothing further.
Your Honor, I would like to mention that 855 Roswell, that apartment is actually Mr. Holmes' apartment. He lives there, and Miss Brooke Roach does not live there, and he is the only one who is on the lease. So staying away from that address is not appropriate, and yet staying away from her place is absolutely fine with her, fine with my defendant. And of course, 3 weeks ago, whatever happened was never reported, and I don't think that shouldn't be impacting this case. We have to be focused on this one, and there was no injury whatsoever, and we would like to request for a signature bond, Your Honor. Thank you.
Your Honor, what I've stated on the record goes to the Ayala factors of intimidation of witness, so it is very relevant to this case. And to add, Your Honor, the victim is in fear of the defendant, so she wants no contact.
And do we have a stay away address as opposed to the Roswell Creek address?
That's where they both live, Your Honor. So that's the address that we have. It's the 855 Roswell Creek, Apartment C.
No longer she resides there, Your Honor. So maybe we can have a condition that he can go there and make sure that she's not there, and she can come to, he can come to his house.
So, Ms. Tortorello, you don't have a different address for the victim, is that correct?
Correct, and she's asked us for him to stay away from the residence.
And who read or who told me that he had packed his things in his vehicle?
The victim advised us of that, Your Honor. But again, we don't oppose for him to have, if it's more reasonable, a one-time escort just to assure that he has his things, as long as he comes in with a deputy.
Okay. All right, we just wanted to make sure that our victim is safe, obviously. I'm going to, order, oh, I know what else. One other thing, Miss Kim, you did
Yes.
not, you stated that, as far as his work history,
Yes,
and you stated
He
that
had-
he was supposed to start a job on Monday.
yes, Your Honor.
Okay. And the children are not between the two of them. They're the victim's children, but not his children.
That's correct, Your Honor.
All right, I'm going to go ahead and order the $5,000 signature bond through pretrial. I'm going to order a no further contact with the victim, Brooke Roach. And I'm going to order a stay away from the 855 Roswell Creek Apartment C as long as the victim does not reside there. So, Mr. Holmes, what you can do is when you are released, you are to arrange for a police escort to that location. And if Miss Roach is still residing there, you cannot reside there. And you will have that escort with you to retrieve your personal items at that time. If she later moves away, then you can take back up living there since your name is on the lease. But in order to ensure that our victim is safe and her two children, you cannot reside there as long as she is residing there. Is that clear?
Yes, ma'am.
And I'm gonna order you to take the one-day anger awareness course. No drugs, alcohol, or weapons while on bond, except for anything prescribed to you. And I think that's all I need to take up. Is there anything else?
No, Your Honor, nothing further.
All right,
Nothing for the state, Your Honor.
all right. That will conclude this case.
Thank you.
Huh?
Your Honor, can we go back to position number one, Mr. Anthony Jabri?
Okay. All right.
And Your Honor, that is going to be a pro se plea. Mr. Anthony wishes to take the time served plea.
Okay. All right, again, this is case number 22 CR 002273J. And this is State versus Jabri Anthony, is that right?
Jabri Anthony.
Okay. And Mr. Anthony, you choose to go forward and represent yourself, is that correct?
Yes, ma'am.
And you are aware of any consequences in representing yourself, I'm assuming?
Yes, Your Honor.
All right, and you want to plead guilty to a time served plea on the charge of possession of marijuana less than an ounce, is that correct?
Yes, Your Honor.
Okay. Ms. Melnick, this is your case, correct?
Yes, Your Honor.
And that is your understanding, time served, pleading guilty to possession of marijuana less than an ounce, correct?
Correct, Your Honor.
All right. And again, I'm going to inform you, Mr. Anthony, to remember that you do have a right to remain silent, and anything that you say about the facts or occurrences of your case can and will be used against you. So you do have a right to remain silent,
I understand.
okay? And so at this time, I want you to raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
Okay, I have heard the state's recommendation for the plea. You are agreeing to represent yourself pro se for this plea. And I need to ask you a few questions first before I accept your plea. State, do you, well, I shouldn't, I'm getting mixed up because I don't have PDs. And I'm assuming you will consent to the venue, identity, and the facts of the case as we know them to be. Is that correct, Mr. Anthony?
Yes, ma'am. Yes, Your Honor.
All right. And I need to ask you, are you under the influence of any medication, drugs, or alcohol at this time?
No, ma'am.
Are you satisfied with the plea that has been offered to you from the state?
Yes, Your Honor.
Do you understand that by pleading guilty, you're giving up or waiving your right to the presumption of innocence?
Yes, Your Honor.
And do you understand that by pleading guilty, that you have the right to remain silent and not testify against yourself?
Yes, Your Honor.
And do you understand that by pleading guilty, you're waiving or giving up your right to a trial by judge or jury, whichever you prefer?
Yes, Your Honor.
And do you understand that you're agreeing to waive these rights?
Yes, Your Honor.
Has anyone told you that you receive a lesser sentence for pleading guilty?
No, ma'am.
All right. Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
And so as to the charge of possession of marijuana less than an ounce, how do you plead?
Guilty.
Okay. And how are we going to get our plea paperwork to us? Are you able to email or fax it to the jail, Ms. Melnick?
Yes, if you send me an email address, I can send it right on over.
All right, where should she email that to, Mr. Jordan?
I can send it to Mr. Jordan. I know. What do you want?
Okay, Mr. Jordan, do you want her to send it to you?
It should go to the jail judge so he can sign the paperwork.
Okay, it needs to go straight to the jail.
Mr. Jordan,
Yes.
let her send it to you and then you can send it to me, Officer Norris. And then
Okay.
I can from there.
Okay, yes.
Okay,
All right.
all right, that sounds good.
Okay, sending it in a second.
Okay, and so, Mr. Anthony, that will be the disposition of your case as a guilty plea for time served. And then you can go forward now and address your other matters, okay?
Thank you so much.
All right, thank you.
Next, we have position number 5, Mr. Armando Ford.
Case number 22 CR 002277C. Armando Ford. You're charged with 1 count of criminal trespass with the offense date of April the 15th, 2022. Retrial.
9 cycles, four out of Mississippi, 5 out of Georgia, a 2018 conviction out of Mississippi for obstruction of a police officer. The last arrest was November 6, 2021 for criminal trespass in Wilkinson County, Georgia. All of his arrests out of Georgia are for criminal trespass, except for the first one in 2009, and none of them have disposition, so they all appear to be open starting in 2021 out of Albany. Nothing further.
All right. Ms. Melnick.
Yes, Your Honor, I have the right defendant. Yes, he is charged with trespassing at the Ritz-Carlton downtown. He was asked to leave. He was not a guest of the hotel and been asked to leave several times before. He refused to leave and he was transported to Fulton County. Given that he still has several open cases, the court has previously set a surety bond of $2,500. I think that is appropriate in this case. And we'd ask the court to not amend it or modify it.
I'm gonna represent myself. I'm gonna represent myself. I'll fire my attorney.
Mr. Ford,
I'm gonna represent myself.
all right, there's consequences to that, and you are to know all the rules of evidence to
Yes.
represent yourself.
Yes.
I guess, Ms. Thomas, do you have any issues with that?
No, Your Honor, Mr. Ford is entitled to represent himself if he so chooses. This is my first time hearing this, so
All right.
Okay, basically, Your Honor, my attorney at law is, I just got out of, California, and I just got down here. I booked a trip to go to, the Ritz-Carlton in, California, and I came down here 3 days ago in my car with my security. And my cousin works there. My first cousin works at the Ritz-Carlton Hotel. And basically, I got caught up in, the unnecessary stuff. I had 2 cups of coffee. I got loud with the police officer, and, it was some words exchanged and everything. It wasn't a criminal act.
Your Honor, this is not a trial, as the court knows. This is the purpose of bond is to determine one, if he is.
And I
a
think that's kind of
danger.
outrageous to try to charge me $2,500 for a bail.
Hold on. That's what your bond is. It's usually 10 to 15% to get out on the bond through a bonding company. So it's not.
I just called the fire department. I called my cousin Tony Case and Ford to come down there because they had a homeless guy standing outside, and the guy wanted him to fall flat on his face, and I helped the guy up at the Ritz.
Okay, so all of that is irrelevant to your case at the moment.
Yeah.
Tell me how old you are, Mr. Ford.
31.
Okay. And are you currently working?
No, ma'am, but I have job opportunities open.
Okay, and you just moved here a few days ago, correct?
No, I didn't move here. I'm visiting my cousin. I'm visiting to play the NFL and stuff. And I posted.
So you're a resident of California?
No, I'm a resident of Georgia. 1604 Long Bridge Road, Jeffersonville, Georgia.
Jeffersonville, Georgia?
Yes, ma'am.
Okay. Wanted to caution you, be a little careful. You are giving too much conversation to the facts that things could be used against you. So I need you to hold back a little bit. As far as your bond and what I've heard of your criminal history, I'm going to continue with the surety bond of $2,500. And so when you go through a bonding company,
yes, ma'am,
you to pay somewhere between 10 to 15% of that amount. So it's not a cash bond. It's not a $2,500.
That's outrageous, Your Honor, because I just helped the homeless guy. I just gave a dude a shirt.
That doesn't have anything to do with my bond statement that you helped a homeless guy.
Can I have time to call my lawyer? I'll call another lawyer. Let me call
I can reset your case till tomorrow if you want to get another lawyer.
Let's do that. I gotta get another lawyer on my case.
All right, I will just reset your case till Monday. Monday is the 18th. And you're gonna get private counsel here by Monday?
Yes, ma'am.
Hey, come sit over here. The judge is talking to you.
That's outrageous. $2,500. I just paid. I gotta pay $700 to my driver to come to the Ritz, and I just talked to Seattle Seahawks, and I'm getting all these charges on me.
Your Honor, I think this is an MH case.
Yes, maybe.
Your Honor.
Thank you.
Your Honor, I'm getting all these charges on me from. I was locked up in Macon. I was locked up in Wilkinson County.
Come on, Ford.
Okay, we're gonna I need you to stop talking. We're gonna reset your case till Monday so that you can get private counsel, and then we can see what else we need to do with your case on Monday if you're not ready to go forward today.
Your Honor, I did notice in the GCIC in a different state where it's different rules, he did have a MH commitment hearing.
You did?
Yes, Your Honor.
All right, come on.
Well, with him not being represented, but I can go ahead if you want and have an MH eval ordered.
I think that would be appropriate.
Okay.
Because it was only, it's only 10 years ago, but it's in a different state where they have actual commitment hearings. So it was on the GCIC.
Okay, thank you for that. All right, so we'll do that and then reset him.
Come on.
Come on, Harris.
Position number 6, please, is next.
Okay. This is case number 22 CR 002278E. Mr. Christopher Harris, you're charged with 1 count of criminal trespass with the offense date of April 15th, 2022. Pretrial.
What was the
Your Honor,
position
before we
again?
go, may I please interrupt? I would like to request for breakout room for MHE concern.
Okay, let me hear from pretrial.
Yes, sir. Yes, ma'am.
10 cycles. Last arrest was November of 2018 for FTA. Has another FTA from 2018, a 2017 criminal trespass conviction, a 2014 misdemeanor marijuana possession conviction, and then appears to be on probation for possession of cocaine, 17 SC 148987 from November of 2019, 3 years probation. Nothing further.
And correct me if I'm wrong, pretrial, but I also have that he has an open carrying concealed weapon and a theft by receiving stolen property felony.
I don't see that on his GCIC.
All right, I also see someone trying to get on or did, Mr. Adrian Harris, and now I see.
I'm sorry, Your Honor, that's my witness for Mr. Reed.
Okay, not in this case. I saw the Harris.
No,
last name.
Your
Okay,
Honor, sorry
just
about
making
that.
sure. No problem. Thank you. All right, we need to go into a breakout, Ms. Kim.
Yes, Your Honor.
And Your Honor, since you all are doing a breakout, I also requested a breakout for position 15. Would it be easier to handle both cases in a breakout session, or would you just want them to do them one at a time?
You can go ahead sometime.
Yeah, one at a time. I've not heard the evidence on that one yet, so
Okay.
hold for Ms. Thompson. Thank you.
Okay, thank you.
Okay. All right. Hold on a second, Mr. Harris. We're going to go into a quick breakout, Mr. Jordan. So that would be myself, Ms. Melnick, Ms. Kim.
Come back to you. You can stay right there.
All right.
They're gonna come back to you.
Leave that alias needs to be denied.
No, they don't take all that. Hey, Mr. Jordan. I don't see Mr. Jordan.
He probably is in the,
Oh, yeah, he probably been out.
All right, Mr. Harris, can you hear me?
First go turn. Okay, confirmation, yes.
Okay, we're going to, I'm going to issue a surety bond in your case in the amount of $5,000. And I'm going to order NHE eval and reset your case until April 28th, okay?
I only have 196. What I was going through in bookings was more like we had to change addresses from 175. That would have never made 400, and then my bond release. Well, under 100, I don't believe I need a new bond release. I'm already Georgia Tech's civics major and superior jet bonding director.
Mr. Harris, I would like to emphasize that you have your right to remain silent.
Okay. So we'll reset your case to the 28th and look and see where we are at that time. Okay, Mr. Harris?
3 weeks. And
That's what we'll do.
all right, come on, Harris.
Thank you.
You're welcome.
Come on, Harris. Next, we got position number 9, Mr. Chris Paris with a P. Chris Paris.
Oh, I see. Okay.
Okay.
This is 22 CR 002280J. Mr. Chris Parrish, you're charged with 1 count of theft by receiving stolen property, offense date February 13, 2022. Do you have anything pre-trial?
Yes.
Okay.
Yeah, 16 cycles. Last arrest was December 25th, 2020 for obstruction, theft by receiving stolen property. That is an open case, 20 CP 196386. He also has an open case for possession of a firearm by convicted felon, theft by receiving stolen property. I'm sorry. The case number I just read out was for theft by receiving stolen property. The last arrest case number is 21 SC 178346. He also has a third open case for entering auto, theft of mislaid property and obstruction, 21 CP 205105. That is an open pretrial case and we're surrendering that bond. He appears to be on probation for theft by receiving stolen property, 18 SC 157736. That is from March of 2018. He has a FTA from 2019 and a probation violation from 2019. And he also has an open felony case that he was in felony first appearance this morning. And that is for possession of a firearm by a convicted felon. And nothing further.
All right. Ms. Tartarella.
Yes, Your Honor. For the theft by receiving stolen property, the state's recommending that the $1,500 surety bond set by the judge be increased to a $5,000 surety bond. No contact with the victim, Marcellus Dumas, that's spelled M as in Mary, Arcellous. Dumas is spelled DU, M as in Mary, AS. To stay away from all Walmarts in Fulton County. To take a theft class, to relinquish all firearms, no weapons, no drugs or alcohol, and no new violations of Georgia law. Your Honor, in this case, the defendant, Chris Paris, received a stolen cell phone that belonged to victim Marcellus Dumas. And he then sold it in exchange for United States currency. This occurred on February 13th, 2022. The Atlanta police obtained information from the victim, Mr. Dumas, that his white 2005 Nissan Altima had been broken into and several items were stolen, including a gray Apple iPhone XR. On February 14th, 2022, the defendant, Mr. Paris, went to an Eco ATM machine at the Walmart located at 835 Martin Luther King Jr. Drive in Atlanta, Georgia. The defendant presented his Georgia ID in exchange in order to exchange the Apple iPhone XR for cash money. The defendant received $27 for the iPhone. Officer B. Porter received this information through leads online. The defendant was arrested on April 15th, 2022, and all these events did occur in Fulton County, Georgia. Your Honor, as you've heard from pretrial, the defendant has several open felony cases. She's read those case numbers to you. He currently actually has 5 open felony cases, one being 13 PF 004829, violation of probation for burglary, for his burglary case. He is in violation of 3 bond orders, as pretrial has stated to you. This is 21 SC 178346, incident date of December 11th, 2020. That one's a violation of bond. 21 CP 205105, the entering auto case. Incident date December 10th, 2021. That one's a violation of bond, as well as 20 CP 196386, theft by receiving, incident date of April 7th, 2020, violation of bond. To add your
I'm sorry, I do apologize. The smoke detector is going off and he's having a hard time hearing. So can we be back? Can we just do a recess real fast, please?
Okay, we'll recess. Yes.
You can go to the sub annex, Your Honor.
Go to the top
Okay.
annex. Thank you.
Thank you.
We have the 4 ladies right here. Hold your head up, young ladies. They need to get their rights heard.
Okay. All right, at the South Annex, I'm Judge Regina Mincy, and this is our state court expedited accusations calendar. And this is a calendar for cases where the persons have been recently arrested and charged with certain misdemeanor offenses. After the arrest, these cases are already accused and have been bound over to the state court of Fulton County. And we will address your case today regarding bond. If a possible plea offer has been made by the state at this juncture, we can handle that as well. And I want everyone to know that this whole entire proceeding is being recorded and live streamed on YouTube. So govern yourselves accordingly, listen to your attorneys. I also want to remind you that you have a constitutional right to remain silent, that anything that you state about the facts and occurrences of your case can and will be held against you. The prosecutors are listening. So again, listen to your attorneys and govern yourselves accordingly. Who do we have first?
Position number 2, Ms. Brown.
Okay.
I'm sorry, Judge. After that position, we can come back to courtroom 2, please. Thank you.
Oh, okay. I see.
Yes, thank you.
And this is position 10, deputy in South
Number
End.
Number 2.
02. I apologize. Is it Jalen Brown?
Yes, ma'am.
22 CR 002274A. You're charged with 1 count of theft by taking with the offense date of April the 15th, 2022. Do you have anything pre-trial?
5 cycles, 2015 conviction for criminal trespass and disorderly conduct. Last arrest was March 5th, 2020 for armed robbery, aggravated assault, and contributing to delinquency of a minor. He appears to be on probation for robbery and aggravated assault with intent to rob. Case number 20 SC 175834. Disposition was December of 2020. It was a 10-year sentence. And nothing further to add, Judge.
All right. And this is Ms. Melnick's case?
Yes, Your Honor. This is State versus Jalen Brown. Basically, she's accused of stealing a wallet, cell phone, driver's license, and social security card, and with the intent to deprive said owner by taking these items in the backseat of a car. And given that she's on probation for robbery and aggravated assault, she presently has a $2,500 surety. The state feels that this is appropriate, and we're asking the court not to modify it in any.
Okay. And Ms. Thomas, is this your case, or Ms. Kim?
This is my case, Your Honor. Thank you.
Okay.
Your Honor, I've talked to Ms. Brown. We are denying these allegations. It is my understanding that the alleged victim is a friend of the family's. It's also my understanding that Ms. Johnson has her personal belongings and that my client did not take any of her personal belongings, Your Honor. So we are disputing these allegations. Ms. Brown is 25 years of age. She has been a Georgia resident forever. Her family resides in this state. Ms. Brown is also gainfully employed, and she's also obtaining her CDL license through the Goodwill Career Center. Your Honor, we'll be asking for a signature bond on Ms. Brown's behalf. Like I mentioned, Your Honor, we are denying these allegations. Ms. Brown did also express to me that she is unsure of her ability to make this $2,500 bond at this current time. So we are asking for a signature bond. If the court is not inclined on granting that signature bond, I am asking for a bond amount no more than $1,000 at this current time.
All right. And so let me go back to Ms. Melnick. The victim in this case is Ms. Johnson. What's the victim's first name?
I'm going to spell it J'_CLINCIA, Johnson.
Okay.
Your Honor, we also ask to stay away from Ms. Johnson. No weapons, and no drugs, no alcohol.
No opposition to the stay away.
Okay. And what's the stay away location?
It's going to be 699 Ponce de Leon Avenue.
Okay. All right. In this case, I'm going to continue with the bond amount of $2,500. Surety bond. I'm going to order a stay away from the location of 699 Ponce de Leon Avenue. I'm going to order no further contact with J. Clinicia Johnson. No drugs, alcohol, or weapons while on bond. And I believe that's all I'm going to order at this time. That should conclude this case unless there's anything else from the attorneys.
No, Your Honor.
Can I confirm with my client, Your Honor, that she doesn't need a one-time escort to go back to that location to gather any personal belongings?
Okay.
Ms. Brown, do you need to go to that location at all?
Just one time. It's my
Just
auntie
one time.
house.
Can I get a one-time escort?
All right, and I will order that you be allowed with a law enforcement escort to go back to that location one time to retrieve your personal belongings. Make sure you arrange to have a law enforcement escort, okay? All right. All right, that should conclude this case. Thank you.
So I still gotta pay the bond?
If you can make bond 2,500, the 10 to 15% of that through a bonding company.
All right, thank you.
Judge, we can go, return back to position number 18. No, I'm sorry, it's not 18. Mr. Paris, please.
Yes, we were, sorry, South Annex, we were in the middle of it when the smoke detectors went off. So let me finish position number 9 with courtroom 2, okay? Mr. Chris Parrish.
Yes, ma'am.
All right, we were at 22 CR 00228080J. And I believe I had heard most everything except for, was there anything else, Ms. Tartarello, that the state needed to present?
It relates to his bond, yes, Your Honor, his convictions.
Okay,
He was convicted of theft by receiving in Fulton County Superior Court on May 31st, 2019. Then he had another theft by receiving conviction on March 19th, 2018, and he VOP'd on that. He had a August 26, 2014 burglary conviction out of DeKalb County Superior Court. And then a May 8th, 2014 theft by taking burglary, Fulton County Superior Court conviction. And he also VOP'd on that, Your Honor. He does have an FDA on his record. And again, I'm asking for a $5,000 surety bond for this, nothing further.
okay. All right, and Ms. Kim?
Yes, Your Honor, Mr. Chris is 26 years old and he stays with his mother. So he's okay with stay away from Walmart. That is fine with him. He has been here in Georgia for 26 years. He does not have children, but he has his family here. And he is currently employed at Waste Pro Management Company as a wasteland cleaner for last 3 months. And he recently got his Amazon warehouse worker job for about last 1 month. So he's gainfully employed and he would like to continue his job. So to do that, he has to get out of the jail as fast as he can. And he has 11th grade high school education so far. I do understand because of previous conditions, he would like to, he understands. However, he claims that that iPhone XR is his own phone that he bought. So we would like to request for signature bond. And if Your Honor is not inclined to give him signature bond, we would like to request for $1,000 surety bond, Your Honor. Thank you.
And Your Honor, just to add briefly, the state is moving to transfer this to Superior Court for repeat offender. This is like his 4th theft by taking or receiving stolen property.
Okay. All right, I'm going to increase the bond to $4,000. $4,000 surety bond. Gonna order a stay away from all Walmart stores in Fulton County. Mr. Parrish, please do not go to any Walmart stores. You will be arrested if you do that. So while you're on bond, and this case is open and pending, please do not go to Walmart. You got to shop at other places. No further contact with Marcellus Dumas. No drugs, alcohol, or weapons while on bond. And I'm going to also order that if you have any firearms, they should be relinquished to law enforcement while you're on bond as well. All right, anything else I need to take up?
No, Your Honor.
All right, thank you.
Thank you.
Can you repeat the last part about the enforcement?
You to turn in or relinquish or give up any weapons that you may still have in your possession, and make sure that you give them to law enforcement. It is a condition of your bond that you not have any weapons in your possession.
Yes, ma'am.
All right, thank you.
Don't go to position number 10 is next, Judge. Mr. Reed, please. Come on.
Okay. Case number 22 CR 002259A. Casey Reed, you're charged with 1 count of simple battery family violence with the offense date of January 28, 2022. Pretrial.
Give me 1 second, Judge. I have to find this history. He wasn't on my pull sheet.
Oh, he's not.
No, he wasn't on the pull sheet.
Your Honor, he has 1 cycle out of North Carolina. And I'm not sure if pretrial sees anything for Georgia. I can look it up too, right, more quickly.
He has, I'm looking. He has 24 cycles out of Georgia. The last arrest being September 4th, 2020 for cruelty in the third and battery family violence. He also has that was with Rayfield. He has an August of 2020 arrest, also for battery family violence and cruelty. There's no disposition on either, so that case, those 2 cases appear to be open. He has a disorderly conduct conviction from 2014, along with the battery family violence from 2014 that was out of DeKalb County. He has 1 FTA from 2013, a FTA from 2012, a theft by taking conviction from 2013, a theft by shoplifting conviction from 2012, a battery and willful obstruction of a law enforcement officer conviction from 2009 out of Clayton County.
All right, that's good.
Okay.
Yeah, thank you. Okay, Ms. Tortorella.
Yes, Your Honor, we're asking for his bond to remain as set for a $5,000 surety bond. The judge yesterday during SEA granted him a $5,000 surety bond. The conditions is that he have no contact with the victim, Miss Adrienne Harris. The first name is spelled A-D as in dog, R-I-E-N-N-E, Harris traditional spelling. That he stay away from 445 Cleveland Avenue Southeast, apartment M as in Mary 129, Atlanta, Georgia 30354. That he have no weapons, no drugs or alcohol, that he take a 1-day anger management class, and no new violations of Georgia law. Your Honor, this case is about the defendant Casey Reed slapping the cell phone from victim Adrienne Harris's hand and then grabbing her shirt, all because he was angry their dog was barking. On January 28th, 2022, an Atlanta police responded to 445 Cleveland Avenue Southeast, apartment M129 in Atlanta, and involving a domestic dispute. The victim, Miss Harris, spoke to Officer Jay Mesidor and said she and her husband, defendant Reed, got into a dispute involving the dog barking. Miss Harris said she was on her phone with her brother when the defendant slapped the phone from her hand. The phone fell on the floor and Miss Harris went to retrieve it, and that's when the defendant grabbed her by her shirt in the chest area. The defendant then followed the dog who was barking in the next room. The defendant advised Miss Harris he had killed their dog, and Miss Harris began to cry as she observed their dog's lifeless body on the floor. The defendant then grabbed the dog and rushed it to Briarcliff Animal Hospital. The argument continued throughout the day, and the defendant decided to take Miss Harris's cell phone, handgun, and $900. The defendant was arrested, and these events did occur in Fulton County. Your Honor, just advising that the state will be adding cruelty to animals, criminal trespass, interference with property, and theft by taking in this case. The victim is stating now that the dog is alive. She stated this to the state, but we need to follow up with Atlanta Animal Control and the police officer in this case. This defendant had 2 previous cases involving the same victim, Your Honor. One is 19 SC 166666 for aggravated assault family violence. It involved Miss Harris, where he strangled her to the point where she felt she was going to pass out. The incident date was September 4th, 2018. That case was dismissed. There's currently an open case, Your Honor, 20 CP 193871 in Superior Court, battery family violence. It involves Ms. Harris again. Incident date April 19th, 2019. He was released on a signature bond in this case, Your Honor, through pretrial for $11,000. He's currently in violation of this bond, Your Honor. For that reason, Your Honor, given you've heard from pretrial his criminal history, he has a risk of reoffending. He has a risk of intimidating the victim, Ms. Harris, in this case while he's out on bond. And for that reason, we are asking for the court to have the $5,000 surety bond remain as set. Nothing further from the state.
Okay.
Your Honor, I would, before I get into my argument, I'd like to call Ms. Harris to testify first.
All right, I see Ms. Harris on the screen. Ms. Harris, can you turn on your camera?
I'm here. It's on, Your Honor.
Oh, there you go. Okay, I apologize. Ms. Harris, do you wish to address the court?
Yes.
Okay. And would you raise your right hand for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
Okay, and what would you like to tell me about this incident?
Well, everything that they saying is not quite right because of the time frame. Because when he ran and took our dogs to Briarcliff, I came right behind him. And we didn't even get into it at our house. We got into it in East Point. But the police was already here when I got home.
Mm-hmm.
So the time frame, and then they say he with the dog being barking, the dog was never barking. Like I explained to the court yesterday, the dog had urinated in front of the door. And that's the only reason why we got into it, because of me thinking that the dog had he did something to the dog. That's the whole reason why we even got into it in the first place.
Okay, are you in fear of Mr. Reed?
Not at all.
Okay, do you have any fears of him coming back to the location on Cleveland, the 445 Cleveland?
No, ma'am.
You don't fear for your safety?
No, ma'am.
Okay, and so whose name is on the lease here at 445 Cleveland Avenue?
Mine.
Okay, is his on it at all?
He paid the rent. He's the one who paid the rent. It's just my name on the lease. He's the one who go to work and pay the rent every month.
Okay. Okay, let's see. Is there anything else? Does anyone want to cross-examine Miss Reed? I'm sorry, Miss Harris.
Reed, we're legally married.
Oh, your name is Reed?
Yes.
Okay. How long have you all been married?
We've been married going on a year next month, May the 7th.
Okay.
Your Honor, I would like to ask her a few questions as she is the state's witness.
Okay.
Ms. Reed, you stated that here in court on the record that the dog was not barking. Is that correct?
No, the dog was not barking at all.
Okay. But is that what you told the police?
No, I told the police the same story that I've been saying. The dog urinated.
Okay. And you didn't tell the police officer, and I'm quoting that the defendant, you got into a dispute involving the dog barking.
No.
You didn't say this. Okay.
No.
And if there's a body camera, will it in fact say what you're saying right now, that you did not say that the dog was barking?
Yes.
Okay. And also you explained that you have no fear of the defendant. Is that correct?
Not at all.
Why did you call 911 on that day?
I didn't call 911. Once I got here, the police officer stated that it was a call from a man saying somebody finna come shoot the house up. He called the police. I never called the police.
So we get the audio, won't be your voice on the record.
Y'all got the audio. Like I explained to the police, I say, well, y'all didn't never get my phone call when I called the police. He said, no, I'm here for a call that a dude said somebody finna come shoot his house up. That's the same exact word that the police officer told me.
What about your battery family violence open case in Superior Court? Did you call the police then?
I'm going to object to this. I don't see how it's relevant to the bond in this.
It is very
case.
relevant, Your Honor, as it goes to intimidating the victim and the witness.
The facts of that case, which my understanding is either open or dismissed, again, is not relevant to whether a bond is sufficient. In this case, she has already stated on the record twice that she is not afraid of him, nor does she have an issue. I think that nor does she have an issue with him returning to the residence. That's more than enough to address that issue.
Your Honor, I've done bond hearings before, and I've been able to provide facts of other matters in order to fulfill the factor of intimidating victims and witnesses. So,
Your Honor, I would respond
a little bit. I'll allow a little bit into it, but not great detail. But ask a few questions, Ms. Tortorella. Let's see where we go.
yes, Your Honor. So, why did you call the police for the open battery family violence case that occurred on April 19th, 2019?
April 19th of 2019.
And I just want my objection noted again on the record. I don't believe this is relevant.
Okay, I will, Ms. Watson, Kathy.
April 19th. Probably to get my things back. Once again, only 2 times that I called the police is to get my things back. I never called the police to have him arrested or nothing. I want my things. He tends to, when we get into an argument, I guess he want to take my things. And so I feel like that's the only way I can get my objects, my things back.
Were you injured?
No.
Okay. Your Honor, I don't have any more questions for this witness, this victim. What I do want to stress to the court is that even if she's stating that she's not afraid, this defendant is still in violation of that bond order for 20 CP 193871. I'm assuming there's no contact or no violent contact order with the victim, given the fact that it's a battery family violence case. However, there is a subsequent arrest, and this is another violation of Georgia law, Your Honor, that he's committed under his bond. So for that reason, we object to his signature, and we also object to contact with Ms. Harris, given the fact that he does have an open felony case with her. Your Honor, nothing further from the state.
Okay, Ms. Harris, you all still reside together, you and Mr. Casey Reed?
Yes, ma'am. Like I stated, he's the one who pay all the bills.
Is that at the 445 Cleveland Avenue?
Yes, ma'am.
Okay. And do you have somewhere else you could go reside?
No, I don't have no other family down here. My family's from Florida. He's my only family down here.
And does he have somewhere else to go reside?
Yes, he does.
Your Honor, I don't mean to butt in, but I did confirm that he has somewhere else to go, but no contact order was issued.
Okay, okay.
And I have that address for Your Honor, if you want it. It's his mother's location.
Yes.
I did have it. Hold on. I have it, Your Honor.
It's okay.
It is 1339 Campbellton Road, apartment A as in Apple, Atlanta, Georgia, 30310.
All right. All right, go ahead, Ms. Watson Cafe.
Yes, Your Honor. Mr. Reed is 33 years old. He's a lifelong resident of Georgia. He has 3 children, 2 of which reside in the home with him and Mrs. Reed. He's gainfully employed, as Mrs. Reed has already alluded to. He does pay the bills along with Mrs. Reed in their shared residence. Obviously, he also takes care of the 3 minor children for which he has custody, two again of which live with him. The $5,000 current bond, we were asking for it to be reduced to a $500 bond, and that is based on the fact that on my communication or my office's communications with Miss, the alleged victim in this case, who you just heard from. I'm sorry, I keep thinking Mrs. Harris. These allegations are not only vehemently denied by my client, Mr. Reed, but also by the alleged victim in this case, which this case was brought in protection of. So for all of those reasons, Your Honor, we would ask that the bond be reduced to $500, good bond. And the last thing that I did want, when I spoke to Mrs. Harris earlier, she also indicated that they are currently participating in marriage counseling, which she believes is very helpful for the two of them to move forward and have a healthy and safe relationship. Based on that, we are asking that if a no contact order is in place, that there be some type of carve out for them to continue to participate in the marriage counseling, if Your Honor. At least we'll consider that. That's all I have for you, Your Honor.
Okay.
Your Honor, the state will object to that last part. We strongly encourage no contact at this time.
All right, I'm going to leave the surety bond at $5,000. I'm going to leave all the conditions of the no further contact and to stay away from that 445 Cleveland Avenue location. No drugs, alcohol, or weapons while on bond. And I believe that will be it for this case. Is there anything else I need to add to the conditions on the bond?
I'm not sure if one-day anger management will apply, Your Honor.
We can add on the one-day anger management course. Let's add that on. And we will have to get the information as to where and how to take that course. So again, Ms. Harris or Ms. Reed, who's on the call, he has no further contact with you and is to stay away from your location. So please remember that.
Your Honor, can we allow at least for a one-time escort so that he can retrieve some of his items now?
Yes, and a one-time police law enforcement escort back to that 445 Cleveland Avenue to retrieve any personal belongings or items that Mr. Reed has at that location. All right, does that conclude everything?
Yes, Your Honor.
All right, thank you.
Thanks. May I be excused? That's my own case.
That's it. Okay, we'll let you go. Have a good weekend. All right.
Next, we have position number 11, Mr. Rayfield Simpson.
Okay. This is case number 22 CR 002281B. Mr. Rayfield Simpson, you're charged with one count of criminal trespass, the second count of giving a false name or birth date to law enforcement, both with the offense date of April the 15th, 2022. Pretrial.
6 cycles, 3 out of Maryland, 3 out of Georgia, 1 FTA from 2013, a conviction for violating a protective order from 2017. Last arrest was December of 2021 for criminal trespass out of Fulton County. Does appear to be on probation out of Fulton County for simple battery, 21 CR 005296Y. Disposition was January 13, 2022, 12 months probation. And then the second probation is for criminal trespass, 21 CR 007-590Y. Disposition, same disposition date, 12 months probation. Nothing further.
All right. Ms. Tortorella.
Yes, Your Honor. For the criminal trespass, the state's asking for a $1,000 surety bond. for the given a false date of birth to a law enforcement officer, a $1,000 surety bond, be a total of $2,000 surety. Conditions is that he stay away from all from the Catalyst Midtown Apartments, which is located at 1011 Northside Drive Northwest, Atlanta, Georgia. That he have no weapons, no drugs or alcohol, and no new violations of Georgia law. Your Honor, this case is about the defendant who has he basically went back to the property, to the apartment complex after he was given a criminal trespass warning by the same police officer. On April 15th, 2022, at around 2:46 p.m., investigator C. Goddard of the Fulton County Sheriff's Office received a phone call regarding a suspicious black male at the Catalyst Midtown Apartments located at 1011 Northside Drive Northwest in Atlanta. The suspect was later identified as defendant Rayfield Simpson with a date of birth of August 31st, 1992. The defendant had been given a prior criminal trespass warning by investigator Goddard on March 10th, 2022 from the apartment complex. That case number is 2022-000483 for the record. When investigator Goddard exited his apartment unit and headed to the parking garage, as a property manager advised the investigator that the defendant may be there due to past interactions with him. While looking for the defendant, the investigator observed that he was by the elevator wearing dark black and gray clothing. The officer immediately detained the defendant and asked for administrative information such as his name and date of birth. When the officer asked for his date of birth, instead of giving August 31st, 1992, the defendant gave August 13th, 1992. The defendant was arrested, and all these events did occur in Fulton County, Georgia. Your Honor, as far as risk of reoffending, this defendant recently pled to criminal trespass and loitering and prowling on January 13th, 2022 in Fulton County State Court. This just occurred a few months ago. As far as a flight risk, Your Honor, the fact that he was dishonest to police officers when he was asked his date of birth is very telling, Your Honor, as far as that is concerned. Also, he does have a couple of FTAs. I noticed 2 on his record out of Maryland, December 2016 and 2013 out of Maryland for FTAs. He is a multi-state offender. He has 3 cycles out of Maryland and 3 out of Georgia, Your Honor. So I do believe a $2,000 surety bond is more than reasonable given the circumstances of this matter and his record. Nothing further.
Okay.
I mean, I know when you sign up as an officer, you take the oath, and they said I didn't give them my right name or my right date of birth. I had my information on me, so there will be no reason for me not to do that. So I'm saying, if anything, if the officer is going to lie like that, then I mean, I don't know what to tell you. But I'm not a criminal. I didn't do no criminal acts. I'm a good person. You know what I'm saying? I do have a job and stuff like that. You know what I'm saying? But I would like to say that, you know what I'm saying, I didn't do that. You know what I'm saying?
Mr. Simpson, I strongly recommend you to stay silent. You have every right to remain silent, and I'll speak for you.
Yes,
Mr. Simpson is actually 29 years old, Your Honor, and he did not give any false name, actually. He gave his name, obviously, it was August 13, 1992 instead of August 31, 1992. He had his ID on him. He had no intention to lie about it. I think it was some kind of mistakes that someone was, it could be whoever is, whether it was 31 or 13, if somebody was kind of like not really understanding clearly about the numbers. And that charge, I really think he should get signature bond because he showed his ID on him. So we would like to request for that signature bond. And he has been here in Georgia for last 5 years. He has 2 children, 6 and 4, and he has been working as a cleaner last 2.5 years. He's gainfully employed, and he has finished up to 11th grade at high school, and he would like to continue his job so that way he can be more productive in the society. So we request for signature bond, and yet if not, seriously, for the first part, maybe $250 surety bond, but second part, definitely signature bond, Your Honor. Thank you.
Your Honor, and just to clarify for the record, when the officer saw the defendant by the elevators, he immediately detained him. So he was in handcuffs. Then the officer asked him for his information. I just want to clarify for the record. Nothing further.
Okay. All right, I'm going to order the $2,000 surety bond. I'm going to order a stay away from, is it 1011 Northside Drive? And I didn't catch the name of the apartment complex.
Catalyst, Midtown Apartments.
Okay, I want you to stay away from the whole complex. $2,000 surety bond, no drugs, alcohol, or weapons. And I believe that's it, attorneys. If I have anything else you want me to take up.
Nothing further from the state, Your Honor.
Okay.
Judge, what's the breakdown per charge?
Oh, I'm sorry, $1,000 for each.
Thank you.
Next time will I come to court?
I'm sorry?
When's the next time will I come to the court?
April 28th.
April 28th.
2 weeks.
Unless you bond out before then. All right, thank you. That will conclude this, Mr. Simpson.
Next, we have position number 13, Mr. Strozier, Ricky Strozier.
Did you have anyone to bond out previously, Deputy?
No, we have position number 12 was a medical reset.
Okay.
And also position number 4 is going to be a waiver of appearance.
All right.
That's it.
Okay, thank you for that. This
You're
is this is position 13.
That is correct, Mr. Strozier.
Strozier. All right. This is 22 CR 002283J, Ricky Strozier. You're charged with 1 count of theft by shoplifting. Offense date January the 24th, 2022. You have anything pre-trial?
Yes, I'm showing 23 cycles. Last arrest was September of 2019 for failing to comply with requirements. He does appear to be on probation for offender registry. 19 SC 173139. Disposition was January of 2021. 4 years probation. He has a 2017 conviction for battery, family violence, and willful obstruction of a law enforcement officer. He has a 2004 conviction for failing to comply with requirements. A 2000 conviction for manufacture, sell, dispense a controlled substance. A purchase, possession, or have a controlled substance conviction in 2000. A CWAC conviction in 1995. A battery and a willful obstruction of a law enforcement officer conviction in 94. A criminal trespass conviction in 93. Burglary 86. Simple battery 89 and 84. A parole violation from 2012. And nothing further to add.
All right. Ms. Melnick, this is your case?
Yes, Your Honor. He's presently in on a $1,000 surety bond, and he also has a hold out of Clayton County, is what I'm showing. given his criminal record, I think State thinks that $1,000 surety bond is inappropriate in this case, and we were asking for a $3,000 surety bond in order to make sure that he does return to court and to prevent him or to keep him minimize his danger to the community.
All right, Ms. Thomas.
Yes, Your Honor. We're going to be requesting a signature bond. Mr. Strozer is entitled to a signature bond. This is a Riverside issue. Mr. Strozer has been in custody for 81 days. He was originally arrested on January 24th of this year. He was booked January 26th of this year on this offense and never went before a judge. This is beyond the 72-hour mark. He's been in custody 81 days. This is a Riverside issue. He's entitled to be released as a matter of law. So we are requesting a signature bond for him to be released.
All right. Any response, Ms. Melnick?
Yes, Your Honor. I could not see where he had been in custody on the jailing. I did look for potential. I know that Mr. Jordan did send this to us, but when I pulled him up, it looks like he had gotten into custody or serving a sentence on another charge, is my take on this. But I do not believe this was a Riverside issue.
Your Honor, it says that Mr. Strozer, this case was originally filed on January 26th of 2022. There are no other charges listed that show that he was in custody for any other offense. Therefore, this is a Riverside issue. And even if he was in custody for another offense, being that this charge was filed January 26th of this year, and he was in custody also for this charge, and he had not been before a judge, it is a Riverside issue with or without a warrant.
All right. I'm going to go ahead and grant him a signature bond in the amount of $3,000. I'm going to grant that as a signature bond through the jail. No drugs, alcohol, or weapons while on bond, Mr. Strozer, except for any prescriptions that you may have. You need to keep your attorney in the clerk's office updated as to your current address and where you can receive notices for future court dates, okay?
Yes, ma'am.
All right. So I don't think there's anything else I need to take up at this time, is it?
Nothing further from the defense.
Anything else, Ms. Melnick?
No, Your Honor.
Okay, thank you.
Thank you. Next, we got position number 14, Mr. Wiedemann.
Okay. 22 CR 002284C. Christopher, is it Wiedemann or Weideman?
Wiedemann.
Wiedemann, okay. You're charged of 1 count of battery family violence and a 2nd count of cruelty to children in 3rd degree with the offense date of April the 15th, 2022. Retrial?
He has 8 cycles. Last arrest was August 5th, 2021 for DUI. He does have an open simple battery case, 2 counts, 21 CR 004-108C. That is a pretrial bond, and we're surrendering that bond. Has a 2nd open case for DUI, improper turn, erratic lane change, and possession of an open alcohol container, 21 CR 004-897C. And then he has a 3rd open case for following too closely in DUI, 20 CR 002-423C. And he has 1 conviction from 2016 for reckless driving and nothing further.
All right, Ms. Melnick?
That's my case, Your Honor. ASG
Oh, I'm
21.
sorry, Ms. Tortorella. Yes.
For the battery family violence charge, I'm asking for a $5,000 cash bond. For cruelty to children in 3rd degree, a $3,000 cash bond. It's a total of $8,000 cash bond. Conditions is that he have no contact with the victims. They are juveniles. I'm going to give you the initials, Your Honor. XW and TW. That he stay away from the residence at 8870 Terrace Club Drive in Roswell, Georgia. That he take a 1-day anger management class, ADET, no weapons, no drugs or alcohol, and no new violations of Georgia law. Your Honor, in this case is regarding this defendant. He was intoxicated on the incident date and lashed out at his children. On April 15th, 2022, Officer Carter of the Roswell Police Department responded to 8870 Terrace Club Drive in Roswell, Georgia, involving a domestic dispute. The reporting party, Donna Wiedemann, is the wife of the defendant and the mother of the two victims. Mrs. Wiedemann advised dispatch that the defendant, Christopher Wiedemann, was intoxicated and on the ground floor of the house talking to himself. Upon arrival, the officer attempted to speak to the defendant. However, the defendant advised the officer to go inside the house so that he could speak to his wife and take him to jail. The defendant advised the officer that his child, victim XW, had attacked him and grabbed him by the neck. The officer did not observe any marks on the defendant's neck. The officer then spoke to Mrs. Donna Wiedemann, who stated her children, XW and TW, were helping her move the mattress since the defendant had come home intoxicated. While the children were moving the mattress to the landing on the top of the stairs, the defendant grabbed XW and began to struggle with him. Mrs. Wiedemann stated that the defendant becomes hypercritical when he consumes alcohol, and he was upset with his son about being tardy at school. Ms. Wiedemann advised that the defendant had come home and started drinking alcohol in the patio. The officer did find an empty Corona bottle on the patio table and a mostly empty bottle of liquor under the table. TW stated that once they got the mattress to the landing on top of the stairs, he heard the altercation between his brother and the defendant, but he did not see it. The officer spoke to XW and observed he had lacerations on his left eye and left cheek. XW advised the defendant was intoxicated and walking around the house yelling and acting agitated. XW said his father grabbed him and threw him into the door frame, and the officer observed a smear of blood on it. The defendant was arrested, and all these events did occur in Fulton County, Georgia. Your Honor, just to advise you of these open cases, 21 CR 004897 C involves DUI. This is an incident date of September 11, 2021. He has a $10,000 surety bond, and the state is going to move forward with revoking that bond as he's in violation of the bond order, given this case. 21 CR 004897 C, simple battery family violence, 2 counts. It involves the same victims. It actually involves Mrs. Wiedemann, his wife, and his children. And in this case, the defendant was also intoxicated. The incident date was August 4th, 2021. As you heard from pretrial, he received a $7,000 signature bond. And again, he is in violation of this bond. We are also moving to revoke said bond. 20 CR 002423 C, DUI following too close, incident date May 1st, 2019. He actually FTA'd before Judge Dixon on January 1st, 2022 in state court for this case. He's also in violation of a bond order here, Your Honor, and we're also moving forward to revoke his bond. And as far as convictions, he did have a conviction that reckless was actually a DUI that was reduced to a reckless driving in Fulton County State Court. He had a simple battery family violence arrest out of Roswell back in 2013 with no disposition. And that's it for the state, Your Honor. So we are asking for $8,000 cash bond for this matter, Your Honor. Nothing further.
All right.
Yes, Your Honor. Mr. Whitman is 54 years old. He is a football coach and a teacher. And because he is in pretrial, he understands how much bond that he has to cash out. But anyway, we are strongly opposing cash bond as he is the sole breadwinner for the family. His wife and his 2 minor children, he has to take care of them. He has to pay for the house. He has to make sure that children get supported financially. well, we would like to emphasize that he graduated from college and he has certified teacher. He is working as a teacher for 24 years, and we don't want him to lose his job. That will be very detrimental to all, not only him, but his entire family. They are going through hard time, and the financial burden is extremely difficult at this time. So we would like to request for very, very low surety bond, Your Honor. Cash bond is too harsh at this point, and we would like to request for $7,000 surety bond. Thank you.
Right.
Actually, I want to also emphasize that his wife has a cancer and he has to take care of her as well medically. He's willing to go through the outpatient treatment. So please consider that as well. Thank you.
Okay. Well, I'm concerned if we've got a lot of history here with DUI and alcohol, of what kind of shape Mr. Wiedemann will be in to care for his wife. I'm very concerned about his history, especially as it relates to these DUIs. And I find it quite concerning that he's a coach and a teacher with this kind of history, that he's still on the job at this point. Because he obviously has a problem that is not being addressed, going all the way back to 2016, it looks like, when it starts. So
Ma'am?
you need to consult with your attorney before you speak.
I have an attorney that already assigned to this. He's Jewish. He wasn't able to make it today because of Passover.
You have a private attorney?
Yes, correct. David Baum. He is handling these cases. The case was 3 years ago that is getting ready to be dismissed. As far as the one DUI, I am aware of the behavior. I believe I would rather, instead, I'm not a criminal. I know I have a addiction problem. At the Thursday, I received a shot through my psychiatrist, and I am willing to seek outpatient treatment. I can get into that next week. I do have other children I have raised that are successful. One's a lawyer. I can stay with her. I can stay with my son. I just do not want to lose my job, and my benefits from my wife is very important. I'm really seeking treatment.
Your Honor, since he mentioned that he has a private attorney, I'll be glad to reset this case on Monday, that he can be represented by his private attorney. That would be fine with me, Your Honor.
And that's what I was going to ask, Mr. Wiedemann. Are you going to be able to get in contact with your attorney to come on at this same time at 2 o'clock on Monday to represent you?
Yeah, well, I'm Monday is testing. I would love to be able to get out at a reasonable bond, because this is very important to my children, and I'm very involved with them.
How old are your children?
My children is 15 and 16. The reason I've had some problems, they smoking marijuana, being late for school. While my wife had cancer, I took them to school every day. I was at Crim Open Campus while I was a football coach at Grady High School for 5 years. And they mean a lot to me.
And is your wife still working, or she's not working?
Yeah, she just got back. She hasn't been working, but she just started 3 months ago. She was, in and out of treatment. I own my own house, and I just would rather go through treatment And if you don't want me to stay around my children, I do have a place to go. I just need to be able to bond out so I do not lose my job and my career. I think on all the facts, I have a recording of the video that when my son, I recorded my son angry because he couldn't use the phone. At that way, I've got, he attacked me not in my neck, but he grabbed the phone from my wrist. At that time,
I strongly advise you to remain silent about the facts of the case here, Mr. Rootman, because anything and everything can be used against you.
Correct.
So,
Your Honor, I sympathize with the defendant. However, it doesn't take away the fact that there's now 4 open cases, all involving alcohol. I understand he's concerned about his job. He's concerned about his family. However, he did not show such concern when this incident was committed and the prior incidents were committed, Your Honor. If you are not inclined to give him a cash bond, I would be okay with a surety bond, Your Honor. However, please keep in mind, Your Honor, he, again, we are moving to revoke his bonds, and this would be a 4th open case. Nothing further.
All right, what I'm going to do is to order a surety bond in the amount of $8,000. With $5,000 on the battery and $3,000 on the cruelty, for a total of $8,000 surety bond. I'm going to order that you stay away from the 8870 Terrace Club Drive in Roswell, and you stated that you had somewhere else to go live. Make sure your attorney in the court has your new temporary address so that you can receive the court notices and let us know what address you will be staying at. I'm going to order no further. I'm inclined to do no further contact with your children until you can be in treatment and get the help. It sounds like they'll have some other way to get to school, or their mother can get them to school. I'm going to just say for the time being, no further violent contact with them, XW and TW. But I do want you to get an ADET, the evaluation, and follow the recommended treatment. No drugs, alcohol, or weapons while on bond. I'm going to also order the 1-day anger awareness course. And I think it would be prudent to you, and I'm sure the ADET will come back and say that, but you do need to get into, I don't know, you say outpatient, I say inpatient treatment program. But they will recommend, once they do the evaluation, what you need to do.
Ma'am, that was just for, I'll be out this summer. The inpatient would be for school. And then I am dealing with a psychiatrist, and his name is Dr. Shaw. So I would, if I do, I know what I need to do. So I do not have no problem getting total inpatient. I just wanted to keep my job.
Right. Well, I'm sure by the time you're able to make bond and have the ADET, the evaluation done, it'll probably be May, and school will just about be out. And then you can start that treatment during the summer. And I hope you're ready to do this and to get clean and get yourself together. And usually what I see, and you probably very much aware of this, the children act out and carry on the instability that they have at home. So if they're doing marijuana and acting out, it's probably because of what they're seeing coming from you with your open cases. So you've got bond forfeitures going on, and I guess it's time to finally get all this together, or begin to get this together. So Again, the $8,000 surety bond, no further violent contact with your children, staying away from the residents, and ADET, no drugs, alcohol, or weapons, 1 day anger awareness. Is there anything else either attorney wants to add?
Your Honor,
Nothing, Your Honor.
I would like to clarify, how would the stay away order work with the no violent contact?
Well, he won't be living there, won't be able to go by there, but if in some type of counseling or treatment or something, I guess he could speak to the children. But it looks like he won't be going to live with them or won't be going by the home. But I don't know, do the children go to the school where you work, Mr. Wiedemann?
No, they don't, but I am involved in the football. Both of them are football players, and I am involved with them at the school with the football coach. He's a good friend of mine.
Wow. Well, I'm just surprised that they have you around teens with your record. Maybe they just aren't aware of it, but it
They're
is.
not aware of it.
Yeah, it's very, very discerning to me. I could say no further contact until you begin your treatment. But if there is any positives that you need to be around them in a positive aspect, then you can do that with no violent contact, but obviously not going to your home to have that contact. And Ms. Kim, I don't know what your response would be to no further contact or no further violent contact with these
No
two.
further violent contact, Your Honor.
I'll leave it at no further violent contact and trust you all will begin to heal with counseling and treatment and, get your lives back on track again. All right.
Thank you, Your Honor.
All right. Thank you. All right. Is that it in courtroom 2?
That's it. Yes, ma'am.
All right. Have a good weekend.
Thank you.
South Annex, Your Honor, position number 3, Miss Downey.
Okay.
Good afternoon, everybody.
All right. This is case number 22 CR 002275F. Natasha Downing, you're charged with 1 count of battery family violence with the offense date of April the 15th, 2022. Pre-trial.
Last arrest, 3 cycles. Last arrest July 30th, 2021 for giving false name, address, or birthday to a law enforcement officer out of DeKalb County. That case appears to be open. She also appears to have an open case out of Griffin County for purchase, possession, manufacture, distribution, or sale of marijuana, and purchase, possession, manufacture, distribution, or sale of a counterfeit substance and disorderly conduct. That arrest was from September of 2020. And then she appears to have an open case out of Griffin for battery, and that arrest date was February of 2020. Nothing further.
Okay. Is it Griffin County or Griffin is the city?
It's the city, Griffin Police Department.
Okay.
She also is a multi-state offender with arrests going back. She had juvenile from Delaware, juvenile assault, and which was a felony, terroristic threats. She had another 2011 terroristic threats. She had an 03 disorderly conduct that was domestic in nature. She had an 03 welfare of a child. She had an 04 assault, an 05 assault, and an 07 assault.
Okay.
Given the extremely violent nature of the defendant, she does have no bond. The state is asking for a $5,000 good bond for her to have no further contact with the victim in this case, Mackenzie Shea Hill. They are roommates. Even though it is technically a battery family violence, she is to have no weapons, no drugs, no contact, and to stay away from 1937 North Avenue.
Okay. If they were roommates, both of them were residing at that location?
Yes, Your Honor. It started when she asked for rent money. And then she began punching her on the scene.
Okay. Don't speak. Don't speak, Miss Downey.
I wasn't, ma'am. I just was moving up.
Okay.
In
All right.
fact, what makes it sadder is that Miss Hill had just recovered, was just in the process of recovering from surgery when she was injured.
Okay. All right, Miss Thomas.
Yeah, we are strongly denying these allegations. I spoke with Miss Downing. Miss Downing is actually the landlord of that residence. She has been residing at that residence for the past 4 years. A part of her income is collecting the rent from her tenants. Miss Mackenzie Hill had been a resident there for not more than even a week. When rent was due, she decided to go to Florida, as it was expressed to me, to receive a BBL surgery. Upon her return, Ms. Downing asked for the rent, and that is when Ms. Hill became aggressive and started the altercation. My client has expressed that she was defending herself and will be ready to defend against this charge once trial comes. Ms. Downing is 41 years of age. She has been a resident in Georgia for the past 4 years. She's the proud mother of a 16-year-old daughter who lives at that residence with her. So Ms. Downing it is necessary for Ms. Downing to return back to that residence, as again, she has been living there for the past 4 years and she is the landlord. Ms. Downing has had no history of violence with her tenants, Your Honor, and again expresses that she was only defending herself and has evidence to support her claims. She's 41, Georgia resident. Her family, daughter lives here. She also owns her own business. In addition to being a landlord, she sells clothing and she sells lashes, Your Honor. We are asking for a signature bond. We're not opposed to the no contact. However, given that she does need to go back to a residence where her child is, we are asking for no further violent contact. Ms. Downing does intend on starting the eviction process to get Ms. Hill out of her house. So again, we are asking that she be allowed to return to her residence. We are asking for no further violent contact at this time so that she can return back to her residence, and so that she can start the eviction process, Your Honor. But we are asking for a signature bond at this time. And if the court is not inclined on granting a signature bond, I am asking for a reasonable bond of no more than $1,000 at this time.
Okay, I guess my only question at this point would be, I understand it is Miss Downing's residence and she is the landlord there, but in order to ensure the safety of the victim and so that both parties don't get into any more altercations, I'm not sure how I can safely allow Miss Downing to go back as long as Miss Hill lives there until she does the eviction process. Unless you all have another answer for me for that.
Ms. Downing, do you have another location you and your daughter may be going to until, Ms. Hill can vacate the premises?
As far as myself, I really don't want to remove the baby, my youngest, because all her things is there and things like that.
Right.
But I would like permission to at least pick her up and take her to school, if anything, so she's comfortable in her own bed.
Okay. Your Honor, so
Other than that, yeah, I don't have no problem contacting Miss Kenzie Hill. She already knows I'm trying to get her out from home. So you don't have to worry about no contact with her.
Okay, Ms. Downing, so let me finish speaking. So, Your Honor, in that case, Ms. Downing can find another residence. Her daughter will remain in their home, but she would like a one-time escort so that she can get any personal belongings and for her to be able to take her daughter to school. I don't think that would involve having any contact with Ms. Hill until she can get Ms. Hill out of the residence.
Right.
I understand that, but I feel like in the mornings, when you're picking them up, I think that's just setting it's up for a very tension-filled situation. I don't know how the oldest daughter is, and I don't understand why they can't go so much. Daughter can't walk somewhere else. I don't know how she is. She's standing by herself. Obviously, she may be of age.
Yeah, she said she's 16, is it?
Right. So she can go to a different location and then she can pick her up from there, even if it's a few blocks away, but at least not get into the house so that she has to go in the house.
Yeah, I agree.
Your Honor, if I may, this is Albert Hopkins for the record. Just to point out that, these stay away provisions are for a distance. So, if she's picking her up, they would be could be a certain distance away from that residence that she could pick her up. If she's 16, should be no problem with picking her up at that distance away.
And we're amenable to that. If she can pick her up from some distance from the house, I mean, we don't know what the other location she would be able to reside in to say that her daughter should be able to go with her. We don't know what other situation she may have to put herself in until she can go back home. So if she can pick her daughter up, maybe at the stop sign down the street and take her to school.
Something like that, yeah.
Then okay, can we do that? So her daughter doesn't have to uproot from the house.
Okay, as long as the daughter will be safe. I do have few concerns. If Ms. Hill and Ms. Downing aren't getting along, that we're not putting the daughter in some type of situation where it could be tense or she becomes a victim of any other violence. I want to make sure she is 16. She's not 18. So I want to make sure if it sounds like Ms. Downing is shaking her head that she's okay with her daughter being there without her living there, I'll go ahead and, we'll try that and hope that all will go well with that. So I'm going to order the $5,000 surety bond. And I'm going to order a stay away from 1937 North Avenue until and when the victim is no longer residing there. And I would say, once your dispossessory case is over, I'm going to order no further contact with Miss McKenzie. Is it last name is Hill?
Yes, Your Honor.
Okay, no further contact with her. And in order to pick up your daughter to go to school, she needs to, I'm assuming, go down the street to a stop sign. I think it's what, I'm going to say at least, I think in the order it's what, 50 or 100 yards, 50 yards, maybe
200, Judge.
200. That may be quite far. We don't have too much longer for school. So let's just say 50 yards from the home so that you are, a couple of blocks away. And ask her to come there to pick her up and coordinate that for her safety so that she's not by herself. Even though she's 16, she still needs to be safe.
Yes, Your Honor.
Okay, so at least do not pull up in front of the house. Do not be any closer than say 50 yards or 3 or 4 blocks from the home to pick up your daughter only. Pick up and drop off your daughter only.
Yes.
But no contact with Miss McKenzie at all. No drugs, alcohol, or weapons while on bond. And I think that is it. Anything else, attorneys, that I need to take up?
Nothing from the defense.
Anything from you, Ms. Melnick?
No, Your Honor. Thank you very much.
Okay, thank you.
Thank you, Ms. John. Thank you, everybody. Have a blessed day.
Position 15, Ms. Williams.
And y'all, I request a breakout session for this case.
Okay.
I'm so sorry. Who was this again, Your Honor?
Please going to
Yeah,
break out as well.
This is position 15, Ms. Williams.
You have to pay 10%, between 10 and 15%.
Mr. Jordan, can you put us in a breakout, please, sir?
Who's the ASG on this case?
Portorello.
Thank you.
Mr. Jordan, if you also put me in there with it as well.
Me too, as well. I'm going to be learning and observing.
All right, again, we're back on with position 15, Lakia Williams. To give you my ruling, that will be a $1,000 signature bond through the jail. You to have no drugs, alcohol, or weapons while you're on bond. And you are to stay away from that 12655 Deerfield Parkway. And you understand what that location is, correct? Okay, you're not to go back to that location at all, or else you will be arrested. They're considering you for diversion, so there will probably be some other conditions that you will need to complete for that program. But right now, that's all that I have for my ruling.
May I ask you what diversion is?
Diversion is going to be a program, and I guess Ms. Tartarello can explain to you what that entails.
Yes, ma'am.
Yeah, so the diversion program is through the state. It doesn't require you to take a plea of any sort. You do what is required from the program. You may have to take classes or volunteer. And then after you complete the program, we dismiss your charges against you, and it could be restricted from your record.
Okay,
Okay, so good luck to you, okay?
thank you.
All right.
Next, we have position number 8, Ms. Johnson. Please be quiet.
All right, this is case number 22 CR 002286Y, Shalonda Johnson. You're charged with 1 count of battery family violence with the offense date of April the 1st, 2021. Do you have anything pre-trial?
He has 4 cycles out of Michigan, with the last arrest being in 2009 for an assault. And then she had a 2008 conviction out of Michigan for domestic violence. And nothing further to add.
All right.
You know, this is the case I was pre-trying earlier with the court.
Okay. All right.
Okay, I have that she also has a 2019 battery family violence first offender, and that she was picked up on this case by Glenn County PD. The victim in this case, Ms. Kenesha Cooper, and the defendant are legally married. They did get into an incident where that she punched her twice in the face with an open fist. I'm sorry, with a closed fist. Given the fact that she does have a rather violent history, the state is asking for a $5,000 good bond in this case.
And no further contact with the
No
victim?
further contact, Your Honor, with Kenesha Cooper, and to stay away from 333-4 Peachtree Road Northeast, and no weapons and no drugs.
All right. Ms. Thomas?
Thank you, Your Honor. I spoke with Miss Kenesha Cooper. She actually goes by Miss Johnson. She expressed to me that she wants her wife back at home, and not only wants but needs her back home. She also expressed that she wants the charges dropped. Obviously, that's not how the process works, but I did advise her that she will need to reach out to the solicitor's office so that she can express her sentiments to them. But again, she does want contact with her wife. She is Miss Johnson, in fact, the wife, denies these allegations, and my client, Miss Shalonda Johnson, also denies these allegations, and in fact was unaware of this warrant, being that this alleged incident date took place back in April 1st of last year. The Johnsons have been in continued contact. They live together. They share 2 children together, a 7-year-old and a 2.5-month-old, Your Honor. Currently still living together. They have been Georgia residents for several years now. Miss Shalonda Johnson works at Donaher. She's the engineer there, where she's been working there for the past 2 years with them. Ms. Johnson also completed high school and college, Your Honor. I'm requesting a signature bond on her behalf. We heard that Ms. Johnson had 2 priors out of Michigan that was well over 10 years ago. And then we heard about a first offender conviction, Your Honor, asking the court just to consider that Ms. Johnson does not have significant history priors dating over 10 years ago. I'm asking for a signature bond. I'm asking for her to be allowed to return back to their shared marital home. Her wife wants her home. I spoke with her today prior to court, Your Honor. So we are opposed to the no further contact. We are opposed to a stay away. Again, the state's witness wants her home, wants contact, and expressed that she needs her home to be there with their 2 minor children. So again, I'm asking for a signature bond, and if the court is not inclined on granting a signature bond, a bond no more than $500, given the age of this case and the lack of significant history from Ms. Johnson and the state's own witnesses' testimony that she wants her wife home.
Your Honor, I just really briefly, I know she kept saying that she might want her home, but she never once said it didn't happen. So I think this is a pure case of the battered woman syndrome. It fights exactly the cycle of violence, and we are requesting again the $5,000 good bond to keep the victim safe.
Sorry, Your Honor, maybe I wasn't clear earlier, but when I spoke with Ms. Johnson, Ms. Cooper Johnson, she expressed that this incident did not take place, and my client did express the same sentiments. So
I'm sure she did.
Okay. All right, I'm going to go ahead and order a $5,000 signature bond through pretrial. I'm going to order the 1-day anger awareness course. I'm going to order no further violent contact with Kenesha Cooper Johnson. Going to order no drugs, alcohol, or weapons while on bond, except any prescription drugs that may be ordered. And I won't do the stay away. I'm assuming that, is it 3334 Peachtree Road? Is that where you reside, Miss Johnson?
Ma'am, I don't even know that address. It was 6429 Shadow Court, Douglasville, Georgia. I got 2 houses
now.
I got 2 houses. I got there and I got Florida. I got houses in Florida. But I did want to say one thing.
Ms. Johnson, just answer the judge's question about where you reside, okay?
6429 Shadow Court.
Okay, and you reside there with the victim, Miss Kenesha Cooper Johnson?
Yes, ma'am. Yes, ma'am.
Okay. All right. Well, I'm going to trust that there will be no further incidents by allowing you to continue to reside with Miss Cooper Johnson, since you've been doing that since last year, but no further violent contact, or else you can be rearrested, and no drugs, alcohol, or weapons while on bond, and then you'll have to comply with any other pretrial conditions and reporting. Okay.
Yes, ma'am.
Thank
you. All right. Good luck to you.
All right, Your Honor, that's it for the sub annex.
All right. Have a good weekend.
Bye, everybody.
Bye.
Bye.
And Your Honor, I have the last case, Mr. Keenan Drake, who I submitted a waiver of his appearance to Mr. Michael Jordan.
Hold on, please.
And so we're ready whenever the state is ready for that case.
Let me just ask this. And I don't do first appearance often, but I've never seen a public defender submit a waiver of appearance.
We've had them.
Yeah, we've had them before.
Yeah.
Okay. I was just curious to see.
Sometimes that is the only way to do it.
Okay.
This case? Okay, I was just wondering.
Hold on a second. Let me call this one 22 CR 002276B as in boy. Keenan Drake. He is charged with 1 count of driving, fleeing, or attempting to elude a police officer, and a 2nd charge of driving, hit and run, duty of a driver to stop at a return to the scene of an accident, both with the offense date of October 23rd, 2021. Pre-trial, do you have anything?
Give me a moment. I don't have this file. Was it a reset or something?
Ms. Melnick, do you have his GCIC?
Yes, Your Honor. He has several open felonies for drugs. He has numerous drug charges. He also has a theft by receiving stolen property and attempting to elude. He has a 99 carrying concealed weapon, and he has an 01 manufacturing of drugs. Yes, this case did take place on October 23rd. Is a driving offense where the defendant was in a friend's white Audi. The officer, Q Williams, when she arrived at the scene, she saw the defendant. She has him on her body camera, a picture of him. Okay. And the other officers with South Fulton PD, he did recognize the defendant from other incidents with all the drugs because he's on the fugitive squad. And then when they were initially starting to chase the Audi crashed into a police car and then kept driving. With the new policies of these agencies and not to chase on some of these driving charges and to not chase like this unless it's more of a serious felony. That's why the delay in the arrest. It is not for lack of identity. It is not for lack of the importance of this case, merely the fact that they're trying to keep the citizens safe. Given his continuous drug history and the fact that he did flee, he is a flight risk, and that would assure that he would not be back in court. The state is asking for a $5,000 good bond on this case for each count.
So a total of 10.
Yes, Your Honor.
All right. Ms. Thomas?
Thank you, Your Honor. Mr. Drake is 41 years of age. He's been a Georgia resident all of his life. He expressed that he is an Atlanta resident. He does have family also residing in Georgia. He's a father of 2 children and 1 grandchild. He was previously employed. He was a decal tech for the past 17 years up until his arrest. I believe Mr. Drake has been in custody since March 25th. This is not a Riverside issue, but I do say that to say Mr. Drake was unaware of this warrant. He's been in custody for the past 23 days, and these misdemeanor offenses have just come up on the radar. He had no idea that he had an outstanding warrant for this hit and run and fleeing and eluding. This does come from a October 23rd, 2021 incident date. And again, he's been in custody 23 days now, Your Honor. He currently does have a $27,500 bond on his open felony charges. He hasn't been able to make bond. He doesn't have the means to make bonds. So we are asking for a reasonable bond amount of no more than $2,000. That would be $1,000 on each charge presently. In this case, Your Honor, but because again, he's not going to be able to make bond either way. And I think that would total his bond to $29,500. Your Honor, and obviously he's not going to be able to make bond. He doesn't have any family that will be able to post that bond or go through a bonded company to post bond. So we are asking for a reasonable bond to be set. Nothing further.
Okay. All right, I'm going to order a $5,000 surety bond, $2,500 on each charge. I'm going to order no drugs, alcohol, or weapons while on bond. I'm going to and say no driving unless he has a valid driver's license by DDS, but I don't know that that is necessary because I don't have any evidence that he doesn't, but I'll throw that in there just to make sure. And I guess that is it, unless the attorneys have anything else.
No, Your Honor.
Nothing further. That's my last case.
Okay. All right, we'll wait for Mr. Jordan.
Position 1, I have a time served plea. Position 2 is 2,500 surety bond. Reset 428 SAP. Position 3 is a $5,000 surety reset to the SAP calendar. Position 4 is a total 5,000 surety reset SAP. That's 2,500 per charge. Position 5 is reset to Monday 4/18/22 SCA. Position 6 is a $5,000 surety reset SAP. Position 7 is a $5,000 sign-on bond pretrial. Position 8 is a $5,000 sign-on bond pretrial. Position 9 is a $4,000 surety reset SAP. Position 10 is a $5,000 surety reset SAP. Position 11 is a $2,000 surety, $1,000 per charge reset SAP. Position 12 is reset Monday 4/18/22 SCA. That was a medical reset. Position 13 was a $3,000 sign-on bond jail. Position 14 is a $8,000 surety, $5,000 for charge 1 and $3,000 for charge 2. Reset SAP. And position 15 is a $1,000 sign-on bond jail.
Okay. Let me ask you this, Mr. Jordan, on position 5, where it's reset for him to bring his private attorney for Monday. Do we go ahead and issue the bond? Because I think I said surety bond for 2,500, or do we wait?
You didn't, Judge. You just said the reset. You were about to give him a bond, and then
I was
once he
going
said he
to.
had a private attorney, right?
Yeah.
You just said reset.
All right, we'll just reset then. And I don't have any other questions unless anybody else has anything. Nope. All right. Enjoy the rest of your weekend.
Have a good weekend.
All right, you too. Take care.
Bye, Your Honor.